Welcome to Learn Short and Typing with Vikas sir. Legal matter for Punjab Haryana code and Rajasthan code exercise number 4 600 word at the rate 100 word per minute. Be ready? Start. Pursuant to the order dated 8/12/2009, Counsel for the applicant has placed on record a copy of the order dated 6/2/2008 passed by the division bench of this court in a batch of matters, lead matter being number 135 oblique 2004 entitled Narendra Lal Anand versus Union of India and ANR. He has also placed on record a copy of the judgment and decree dated 31st 3/2009 passed by the reference court pursuant to the aforesaid order of the division bench. Copies of the said judgments have been furnished to the counsel for the respondent Union of India. The present appeal is directed against a judgment dated 31st 8/2004 passed by the reference court in respect of land situated in village Sehbad, Daulatpur, subject matter of award number 1/1998 -99 made pursuant to the notification issued under section 4 of the Land Acquisition Act on 28/4/1995. Counsel for the applicant states that the present matter be remanded back to the reference court for being decided afresh on the same lines as observed in the judgment in the case of Narendra Lal Anand. In the aforesaid case, the division bench allowed the appeals of the landowners seeking enhancement of compensation held payable to them by the reference court and remanded the matters back to the reference court with directions that the references shall be decided afresh after affording the parties an opportunity to lead further evidence in support of their respective versions. The operative parts of the aforesaid judgment are reproduced herein below. In the result, we allow these appeals set aside the judgment and impugned orders passed by the reference court and remained the matters back to the reference court with the directions that it shall decide the references afresh after affording to the parties an opportunity to lead further evidence in support of their respective versions. To avoid any further confusion, we direct that the applicants shall within 4 weeks from the date they appear before the reference court file a list of witnesses and documents which they wish to produce in support of their claim for enhancement and produce all such documents and oral evidence on their own responsibility before the reference court on dates which the reference court shall fix for that purpose. Upon conclusion of the evidence by the applicants, the respondents may similarly file a list of witnesses and enclose documents with the same upon which they place reliance and take steps to examine such witnesses and prove such documents by adducing necessary evidence in accordance with law on dates to be fixed by the reference court. The reference court shall then examine whether the applicant's landowners have any right to lead evidence in rebuttal, and in case they have, permit them to do so in accordance with law. Keeping in view the fact that the matter has been hanging fire for some time past, the reference code endeavor to expedite the disposal of the references and ensure that final orders on the same are passed not later than 6 months from the date the evidence is concluded on both sides. The court shall needless to say lend such assistance to the parties as may be necessary by issuing thusly summons to them for their service upon witnesses and summoning of documents. We further hold that the applicants shall be entitled to refund of the court fee paid by them on the memos of appeal. We direct the issue of a certificate in their favor to enable them to receive back from the collector the full amount of stamp book paid on the memo of appeal. Full stop.